Welcome to Justice Case Files, where every case has a story and every verdict matters.
I have seen a lot of things walk through my courtroom doors in 38 years on this bench. I have seen arrogance. I have seen contempt. I have seen defendants who believed the room owed them something simply for showing up. But what walked through my doors on the morning of April 7th at exactly 10:15 a.m. was something I had not encountered in quite that form before. A 26-year-old woman who laughed, not nervously, not accidentally. She laughed the way someone laughs when they have decided that nothing in the room is serious enough to require their full attention. She laughed at the charges. She laughed at the process. And when she finally looked at me from across the courtroom, she laughed at something I said. That was the last mistake she made in my courtroom. Before I tell you what Vivian Hargrove did on the morning of March 3rd, before I tell you what she said when she opened her mouth and what happened when that laughter finally met something it could not move, I need you to do something right now. I am Judge Vonda. Subscribe to this channel and hit that bell notification because we bring you exactly this kind of story every single week. And drop a comment before we go any further. Tell me, have you ever watched someone treat a serious situation like a joke because they believed their money made them untouchable? Tell me what happened. Tell me if anyone stopped them, because what you are about to see is what stopping them actually looks like. Now, let us begin. Her name was Vivian Hargrove, 26 years old, the only daughter of Elliot Hargrove, founder and CEO of Hargrove Capital Group, a private equity firm with assets under management that placed it comfortably in the top tier of its industry. Elliot Hargrove was worth, by the most conservative public estimates, somewhere north of $1.4 billion. He had appeared on 3 magazine covers in the past 2 years. His name was attached to a wing of the Children's Hospital downtown, to the endowment of a local university's business school, and to the kind of charitable giving that generates press releases and photographed galas, and the specific social currency that money buys when it wants to be seen as something more than money. Vivian had grown up inside all of that. She had grown up in houses that had staff. She had grown up with attorneys on retainer before she was old enough to understand what an attorney was. She had grown up learning through every interaction her environment provided that problems with things that happened to other people, and that the ones that reached her would be handled before they required her direct attention. She was 26 years old, and she had never, not once in her life, sat in a room where her father's name did not eventually resolve the situation. She was about to sit in one. The case before me was not complicated on its surface. Vivian Hargrove had been charged with aggravated assault causing bodily harm, reckless endangerment, and filing a false police report. The events that produced those charges had taken place on the afternoon of March 3rd in the parking structure of the Meridian Shopping Center on the west side of the city. Before I tell you what happened in their parking structure, I want to tell you about the woman Vivian Hargrove put in the hospital. Because in cases like this, it matters. Not because some people deserve more justice than others. Every person who walks through those gallery doors is entitled to equal protection under the law. But because what was done to Nora Osai cannot be fully understood without understanding who Nora Osai is. Nora was 44 years old. She had immigrated from Ghana at the age of 19 with $40, a suitcase, and an address for a cousin she had never met. She had spent the following 25 years building a life in this city through the specific and unglamorous work of showing up every day and doing more than was asked of her. She had worked her way through a community college nursing program while holding 2 jobs. She had spent 15 years as a registered nurse at the city's largest public hospital, working the night shift in the emergency department. The shift nobody wanted, the shift that paid the same as the day shift and asked twice as much. She had 2 children. She had bought her home 8 years ago, the first person in her family to own property in this country. She drove a 7-year-old sedan that she maintained herself because she had taught herself basic mechanics from videos on the internet, because that was the kind of person she was. If you're enjoying this story, take a second to subscribe. It really helps the channel keep making these. On the afternoon of March 3rd, Nora Osai was at the Meridian Shopping Center on her day off, picking up a birthday gift for her daughter. She had found a parking space on the second level and was pulling in when Vivian Hargrove's white Range Rover appeared behind her, horn already sounding. Vivian wanted that space. Nora was already in it. What followed was captured by the parking structure security system on 4 separate cameras from 3 different angles. Vivian got out of her Range Rover. She walked to Nora's driver's side window and knocked on it. When Nora lowered the window to speak with her, Vivian reached through it, grabbed Nora's car keys from the ignition, and threw them across the parking structure. They landed approximately 30 feet away near a concrete pillar. Nora got out of her car to retrieve her keys. While she was doing so, Vivian got back into her Range Rover and pulled forward into Nora's space, striking the open driver's side door of Nora's sedan as she did. The impact knocked Nora sideways into the concrete pillar. Nora Osei sustained a fractured collarbone, a deep laceration above her left ear that required 14 stitches, and a concussion that kept her out of work for 3 weeks. 3 weeks of night shifts at the emergency department. 3 weeks of income that she had already spent on her mortgage and her children's school fees. And the birthday gift still sitting in a bag in the back of the car with the damaged door. When security arrived, Vivian Hargrove told them that Nora had attacked her vehicle. She told them that she had been defending herself. She told them that the woman on the ground had initiated contact. She said it all with the calm fluency of someone who had decided before she opened her mouth which version of events would be most useful. She filed a formal police report an hour later, making the same claim. The security footage made all of that impossible to maintain. But Vivian's attorney had filed 3 procedural motions before the case reached my courtroom, each one designed to delay, complicate, and exhaust. That is the strategy when the evidence is not on your side. You do not fight the evidence. You make the process expensive enough that the other side gives up. Nora Osai did not give up. She had a legal aid attorney named Dennis Park who had reviewed the footage and agreed to take the case on contingency because, in his words to her, this one is not close. Quick reminder, hitting subscribe and turning on notifications means you won't miss the next one of these. The case came to my courtroom on April 7th. Vivian arrived 11 minutes late. Not slightly late, not caught in traffic late, 11 minutes late with a specific unhurried quality of someone who has decided that schedule times are suggestions rather than obligations. Her attorney had been in the room for 8 minutes already, visibly uncomfortable. When Vivian finally came through the door, she was on her phone. She finished the call before she sat down. She did not acknowledge the delay. I said, "Ms. Hargrove, this court was scheduled to begin at 10 a.m. It is now 10:11. Do you have something you would like to say to the court about that?" She looked up at me. She had large sunglasses pushed up on top of her head that she had not removed when she entered the building. She said, "Traffic was genuinely insane today. You know how it is." Her attorney closed his eyes briefly. I said, "Ms. Hargrove, this is a courtroom. When you are scheduled to appear before me at 10 a.m., I expect you here at 10 a.m. The court's time is not subordinate to your schedule. Do we understand each other?" She shrugged. She said, "Sure." And she smiled, not nervously. The smile of someone who has assessed the room and decided it does not require her respect. I noted it. I said nothing further about it. I have learned in 38 years that the courtroom has its own patience. You do not need to hurry it. I called the case. I reviewed the charges. Vivian's attorney rose immediately and began. His client, he said, had been involved in a confrontational situation in a public space. The parking incident had been mutual in its origins. Ms. Hargrove had felt threatened. Her actions have been defensive in nature. The injuries sustained by the plaintiff, while regrettable, were the result of an accident rather than intent. He said all of this with the professional smoothness of someone who had rehearsed it enough times that it no longer required thinking. I looked at Vivian. I said, "Ms. Hargrove, do you understand the charges before this court?" She glanced at her attorney as if checking whether she needed to answer. Then she looked back at me and said, I understand that this has been completely blown out of proportion. It was a parking space. It was a parking space, I repeated. She said, people get into arguments over parking spaces every day. I don't understand why this is a criminal matter. I said, Ms. Hargrove, you reached through another person's car window and removed her keys from her ignition. You then struck her vehicle while she was outside retrieving those keys, knocking her into a concrete pillar. She sustained a fractured collarbone and a concussion, and you filed a police report claiming she had attacked you. Is that your understanding of what happened? She said, that is not an accurate characterization. I said, we have footage from 4 cameras. Let us watch it together, and you can tell me where my characterization is inaccurate. Her attorney leaned forward. Your Honor, my client, I held up one hand. We watched the footage. The courtroom watched Vivian Hargrove pull up behind a car that was already parking. They watched her get out. They watched her reach through the window. They watched the keys arc through the air and land near the pillar. They watched Nora get out of her car and walk toward them. They watched Vivian pull forward into the space, the Range Rover's front corner catching the open door, the door catching Nora going sideways into the concrete. The courtroom was silent when the footage ended. I looked at Vivian Hargrove. She said she should have moved faster.
What makes this moment so shocking isn't just what the footage appears to show. It's Vivian's reaction afterward. The evidence has now been presented directly in front of her, yet instead of showing concern for the injured woman, she continues trying to shift the blame. At this point, the courtroom is no longer dealing with a simple disagreement over a parking space. The judge is looking at a defendant who appears unwilling to accept responsibility for the consequences of her own actions.
The gallery made a sound I had to let settle before I could continue. She should have moved faster, I said slowly. Vivian's attorney put his hand on her arm. She shook it off. She said, I had places to be. If she had just moved her car when I asked, none of this would have happened. I don't see why I'm being held responsible for her choices. I have been on this bench for 38 years. I have heard defendants explain away serious harm with logic so inverted it required a moment to fully process. But I want you to understand what I was looking at across that courtroom. I was not looking at someone who did not understand what she had done. I was looking at someone who understood perfectly and had decided it was acceptable. Those are different things. The first can be corrected through consequence. The second requires something more. I said, Ms. Hargrove, the woman you put in the hospital works night shifts in an emergency department. She spent 15 years caring for people at their most fragile. She bought a home. She raised children. She was on her day off buying a birthday present for her daughter when you reached through her window and took her keys. And you are telling this court that the problem was that she did not move fast enough. Vivian met my eyes without difficulty. She said, with respect, Your Honor, I think you are being a little dramatic. The room went completely still. I removed my glasses. I said, I beg your pardon. She said, I just mean it was an accident. People get hurt in accidents. That does not make it a crime. My father's legal team has handled situations like this before, and they have always been resolved without. I said, Ms. Hargrove, stop. She stopped. I said, your father's legal team is not in this courtroom. You are. And I want to be very precise with you about something. You have just told me that I am being dramatic. You have just told me that situations like this are typically resolved without the inconvenience of a courtroom. You said this while a woman who spent 3 weeks unable to work because of what you did is sitting in this gallery right now. I want you to look at her. Vivian did not look. I said, Ms. Hargrove, I asked you to look at Nora Osai slowly, with a specific reluctance of someone performing compliance they resent. Vivian turned toward the gallery. Nora Osai was sitting in the third row. She was wearing her nurse's scrubs because she had come directly from a night shift. Her collarbone had healed, but the way she held herself still reflected the memory of the injury. She was looking at Vivian with an expression I will not forget. Not anger, not grief, the steady, unflinching look of a woman who had decided a long time ago that she would not make herself smaller for anyone and was not going to start now. I said, that woman worked a night shift last night, caring for strangers in an emergency room. She came here directly afterward because she believes this court means something, because she believes that what was done to her deserves a real response and not a settlement offer with a confidentiality clause. I want you to understand what it cost a person to be here this morning instead of sleeping. Vivian turned back to face the bench. Something has shifted slightly in her expression. Not remorse, not yet, but the smile was gone. The particular lightness with which she had entered this room was gone. Before we go further, if this story is landing with you, subscribing genuinely helps us keep telling them. I said, before I deliver my findings, I am going to read something into the record. Ms. Osei provided a victim impact statement. I am going to read it aloud. Vivian's attorney opened his mouth. I did not look at him. I opened the folder my clerk had prepared and I read, my name is Nora Osei. I am a registered nurse. I have worked the night shift at the city's public hospital for 15 years. I have held the hands of people who were dying. I have talked to families through the worst moments of their lives. I have shown up for strangers in the dark when they had no one else. On the afternoon of March 3rd, I was buying a birthday present for my daughter. I was put in the hospital for injuries that kept me from working for 3 weeks. 3 weeks of night shifts. 3 weeks of the income I had already committed to my mortgage, my children's school fees, my car repair, and the birthday present that is still sitting in a bag in my damaged vehicle because I have not had time to deal with it yet. But the cost I want this court to understand is not financial. The cost is this. My daughter is 12 years old. She was with me in the hospital when I was admitted. She watched the nurses work on me, and she asked me if the woman who did this to me would face any consequences. She is 12 years old, and she was already asking that question. She had already seen enough of the world to know that the answer was not guaranteed. I am here today because I want my daughter to see the answer. I set down the statement. The courtroom was completely silent. I looked at Vivian Hargrove for a long moment. The sunglasses were still on top of her head. The expensive bag was still on the table beside her. But the woman who had walked in 11 minutes late with the phone call to finish and a shrug for the court's time was not quite the same woman sitting in that chair now. Something had reached her. I did not know how deep, but something had. I said, Vivian Hargrove, I find you guilty.
What makes this moment so shocking isn't just what the footage appears to show. It's Vivian's reaction afterward. The evidence has now been presented directly in front of her, yet instead of showing concern for the injured woman, she continues trying to shift the blame. At this point, the courtroom is no longer dealing with a simple disagreement over a parking space. The judge is looking at a defendant who appears unwilling to accept responsibility for the consequences of her own actions.
On all 3 charges: aggravated assault causing bodily harm, reckless endangerment, and filing a false police report, which is not a minor addition to this sentence. You stood in a police station and described a version of events that you knew to be false in order to shift responsibility onto the woman you had just put in the hospital. That is not an accident. That is a decision made after the fact with full knowledge of what you were doing. Here is what this court orders. You will serve 90 days in the county correctional facility, not house arrest, not a monitored release program, 90 days. You told this court I was being dramatic. I want you to have 90 days to consider whether you still hold that view. Upon release, you will complete 180 hours of community service at the night shift intake unit of this city's public hospital where Nora Osei works. You will not observe, you will assist. You will do whatever is asked of you by the nursing staff for as many hours as it takes to complete your requirement on whatever schedule they assign you. You will pay full restitution to Nora Osei, full medical expenses, full lost wages for the 3 weeks she was unable to work, full cost of her vehicle repair, and the cost of her daughter's birthday present, because that bag has been sitting in a damaged car long enough. You will attend a court-mandated accountability program and submit written reflection to this court. And you will write a letter to Nora Osei's daughter, not to Nora, to her daughter. A letter in your own words explaining what you did and what it cost and what you understand now that you did not understand on March 3rd. That letter will be reviewed by this court before it is delivered. Nora will decide whether her daughter reads it. That decision belongs entirely to her. I picked up my gavel. You walked into this courtroom this morning 11 minutes late with a phone call to finish and a shrug for the court's time. You told me I was being dramatic. You looked at a woman who had come here directly from a night shift and decided she was not worth your full attention. I want you to think about Nora Osei's daughter in that hospital room asking whether consequences were coming. I want you to think about a 12-year-old girl who already understood at 12 that the answer was not guaranteed. She is going to get her answer today. The gavel came down. Vivian Hargrove's composure broke in the specific way that composure breaks when something finally lands. Not tears of remorse, the kind that come when a person realizes for the first time in their life that the room is not going to adjust itself around them, that the name and the money and the attorney with the procedural motions and the lightness with which she had walked through the door at 10:11 a.m. had all finally run out of room. She turned toward the gallery. Her father was sitting in the 4th row. Elliot Hargrove, whose name was on a wing of the Children's Hospital and on the business school endowment and on 3 magazine covers in the past 2 years. He was sitting in a plain suit and he was not moving. He looked at his daughter with an expression I recognized from other courtrooms, from other fathers in other rows. The expression of a man who loves someone and is watching that love fail to be enough to change what is happening. He did not stand up. He did not call out. He sat with his hands flat on his knees and he watched the bailiff begin the process and he did not intervene. That too told me something. 5 months later, I received a letter. It was from Dennis Park, Nora Osei's attorney. He wrote that Vivian Hargrove had served her full 90 days. No early release, no special arrangements. 90 days. He wrote that she had begun her hours at the hospital, that the charge nurse on the night intake unit, a woman named Sandra Yaboa, who had worked that unit for 12 years and had seen everything and was impressed by very little, had submitted a report. Sandra wrote that Vivian had arrived the first night looking like someone who had made a calculation about how to get through this. She did the minimum. She stood where she was told. She answered questions in as few words as possible. Sandra wrote that by the 3rd week, something had shifted. She was not sure what caused it. Maybe a specific patient. Maybe the accumulated weight of a room that did not care who her father was. But Vivian had started staying past her required hours. She had started learning names. She had started doing things without being asked, anticipating what was needed, understanding how the room worked, understanding what the work actually cost the people who did it every night without anyone writing about them in a magazine. Sandra wrote, I have had court-ordered volunteers before. Most of them leave the moment their hours are completed. This one asked last week if she could come back on a night she was not scheduled. I told her yes. Dennis wrote at the end of his letter, Nora's daughter received the letter. Nora read it to her. She said her daughter asked if they could write back. They did. I don't know what the letter said. That part is not my business. But I thought you should know it happened. I have thought about that detail every week since I read it. Not because it is dramatic, because it is true in the way that only small things are true. A 12-year-old girl who sat in a hospital room asking whether consequences were coming wrote a letter back. That is not a courtroom moment. That is what courtroom moments are supposed to produce. That is what justice looked like on April 7th. Not the sentence, not the footage, not the moment Vivian's lightness finally gave way. The lesson is the same lesson this bench teaches every time it teaches anything. The most powerful thing in any courtroom is not the gavel. It is character. It is the choice each person makes about who they want to be when the moment actually tests them. Nora Osai had that character. She came here on no sleep in her work clothes, and she sat in that gallery and she did not look away. And her daughter had it too. 12 years old, already asking the right question, already willing to write a letter to the person who had hurt her mother. That is enough. In my experience, that is everything. If you believe wealth is not a shield from what you owe the people around you, hit that like button right now. Subscribe to this channel because these are the stories that need to be told and heard and shared. And leave me a comment right now. Tell me, what would you have done if you had been sitting in that courtroom when Vivian told me I was being dramatic? Tell me honestly, because justice is not only what happens in a courtroom, it is the choice each of us makes when we see someone treat another person as an obstacle. When we have the chance to look away or to stay and say, that is not acceptable. Not here, not today. I am Judge Vonda. One last thing, subscribe before you go. It's the single biggest thing that keeps this channel making these stories. Choose wisely every single time. Choose wisely.
Thanks for watching Justice Case Files. Stay informed, stay curious, and we'll see you in the next case.